Welcome to another show of Open Forum, live from the MTA studios in USA in Washington, D.C. Today we have a great show for you. First, we will examine and explore from September 7th, 1974, where 40 years of the Ahmadiyya Muslim community members being declared kafir in Pakistan. Second, we have an exciting part of this show where we'll explore the idea of the man who is considered the third-grade marshal of Pakistan, and looking ahead to the next 40 years of how the legal community within the Ahmadiyya Muslim community, what are the challenges and how they're going to tackle them. I'd like to welcome you all to the show. First we have Amjad Khan. Mr. Khan is a practicing lawyer in Los Angeles, California with Aiken Gump, as well as he is the National Secretary of Public Affairs. Welcome to the show.
Thank you.
Next we have Mujeeb-ur-Rahman visiting from Pakistan, a lawyer since 1957, I believe, over 40 years of practice. Welcome to the show.
1961 to be right, and 53 years of practice.
53 years of practice, great, even more so. Welcome to Washington, D.C., and welcome to the show.
It's a pleasure.
Thank you. And Mr. Qudus Malik, who is a practicing lawyer, and he just got another degree. What did you just get a degree in?
I have a master's in law now from Georgetown in international human rights law.
Great. Well, welcome to the show. Starting with Mr. Khan, what is the Second Amendment and 40 years of being declared a kafir? What happened?
So, a very peculiar constitutional moment, you can say a historic moment, unprecedented really, happened in Pakistan when the state of Pakistan, the National Assembly of that country, declared that the Constitution, which heretofore did not define who is or is not a Muslim, should be amended to define who is or is not a Muslim. And in that definition, it declared that a Muslim is someone who does not believe in the finality of the prophethood of Muhammad ﷺ, and effectively, explicitly said that Ahmadi Muslims, derogatorily referred to as Qadianis, are not Muslim for purposes of the law. Why is that so important? Is that in a constitution, in an Islamic country that purports to be a democratic country, the National Assembly has declared as a matter of law an entire community to be someone who they profess to be as Muslim, as not Muslim. So in other words, disavowing their deeply held conviction of their identity.
So, Mr. Malik, so this happened in 1974 in September. Then there was this Zahiruddin versus the state of Pakistan. What was that?
So there's something in between. So in 1974, there is a constitutional amendment that declares Ahmadis to be a non-Muslim, and you know, just to give you some context, at that time, you know, before this amendment was passed, Ahmadis had been very active participants in every sphere in Pakistan, every sphere of life. I mean, in 1970, the head of the Pakistan Air Force was an Ahmadi. So
what happened? September 7th?
September 7th, they passed this amendment, and gradually it starts to chip away at the legitimacy of Ahmadis and as Muslims, and chips away at their rights in civic rights.
So then what was the response by it?
So the response then is that then there is added pressure to try and marginalize Ahmadis even more. So before Zahiruddin, in 1984, exactly 10 years, or slightly less than 10 years after the amendment was passed, General Zia, who was a dictator, he enacted Ordinance 20, the infamous Ordinance 20, which basically made it, and now it used the constitutional amendment and made it a criminal offense for Ahmadis now to practice their faith in any form. So just calling for an Ahmadi to call themselves a Muslim became a criminal offense. For Ahmadis to refer to their places of worship as a mosque became a criminal offense. And that is really where, so the amendment, as bad as it was, but it was really the 1984 ordinance that actually took the persecution of Ahmadis to a much worse level.
Mr. Rahman, so what happened between 1974 and 1984? 10 years, you were there.
Yeah.
What was the legal construct of the conversation?
I was there, and if you may permit me, there is a Persian couplet which says, Tan hama daag daag shud, pamba kuja kuja neham. My whole body is bruised with wounds. Where shall I put the balm which shall heal me? So I have gone through that. About 1974 amendment, I should perhaps mention that 1974 amendment, 1974 Second Amendment declaring Ahmadis as not Muslims is a usurpation of constituent function. It is a political heresy. These are two distinct jurisdictions, religion and state. State cannot interfere in religion, and religion should not ordinarily interfere with the state. So that is a long debate, the relationship between state and religion, and conflation of state and religion. These are different ideas. But Pakistan, from the very inception, was supposed to be a modern democratic country, and the founding fathers of Pakistan had envisioned Pakistan as a democratic country. So Pakistan National Assembly had no jurisdiction, and this jurisdiction was in fact challenged by the head of the Ahmadiyya community.
Why do they not have jurisdiction? I mean, they're the assembly. Can't they amend and can't they make ordinances?
You see, again, this is a very there is a detailed debate on this, but to put it very briefly, the political scientists would know that we view state as a result of a social contract. In the modern terminology, constitution is a social contract between the citizen and the state. And James Madison of United States President, he said, when we enter into a contract in our day-to-day dealings, that contract is always subject to the general law of the land. When we enter into a contract with the state, it is subject to our contract with our heavenly Lord. Our contract with God is above all other contracts. So we do it with reservation. The state does not have jurisdiction. Even Rousseau, who was the founding father of that social contract theory, he said state and religion are two distinct jurisdictions. And the head of the Ahmadiyya movement raised that objection on the basis of the United Nations Charter, on the basis of the Article 20 and Article 8 of the Pakistan Constitution, which puts a specific bar that no law shall be made which shall abridge the fundamental rights. So in your language, you call it Bill of Rights. Mm-hmm. Constitution may be amended, but Constitution cannot be amended so as to deprive you of your fundamental rights. Constitution cannot take away the liberty of your thought. That is guaranteed by the Constitution. The head of the Ahmadiyya movement, he was questioned on that by Attorney General. Attorney General was supposed to be the first law officer of the country, and he said, "Why do you say we can amend the Constitution? Why?"
Were you there? Did you hear these debates?
No, but now the proceedings are out. I was not there. I was hanging around all the time around the National Assembly. I was a young boy at that time. But anyway, so he said, "Why can't we amend?" And you know, the third Khalifa of Jama'at Ahmadiyya, he said, because the parliament may be supreme, but the supreme body is bound by the restrictions which has imposed upon itself. So it is the parliament itself who had imposed those limitations, and they could not do it. But it's a long,
But walk me through the series of events real quick. So 74, there's a Second Amendment that Mr. Khan shared. Fast forward 1984, 10 years passed.
Let me quickly take you through that.
Okay.
74 Amendment said Ahmadis are not Muslim for the purposes of law and constitution. It hurt us bad. We were hurt.
It's painful.
But we took it in a stride. We did not challenge that into in the court. We said, all right, I may be a non-Muslim for the purposes of law and constitution. If my Lord in heaven reckons me as a Muslim, and if I am free to allow, and if I am free to practice my faith as I like, if I can hold my allegiance to the Holy Prophet of Islam, Muhammad, peace be upon him, so keep your constitution with you. If your constitution gives me certain rights, I will be tipped. So but we took it in a stride. Just a minute. We took it in a stride. But the mullahs did not.
In response to that, for 10 years, the Ahmadi Muslim community did not legally challenge it at all.
We have not challenged that constitutional amendment so far. But let me go. You asked me what happened in between.
Sure.
We took it in a stride, but the clergy of mainstream Muslim, they were not satisfied. We did not go to court. The clergy, there was a spate of litigation in Punjab where the cases were filed in civil court saying that Ahmadis are not Muslims now. So therefore, what do we do now? Demolish their mosques, take out their minarets. They cannot now pray like Muslims. They cannot call azan. They cannot call durood and salam and all that, invoking blessings on the Holy Prophet. cannot do anything of that sort. They cannot call azan. So they should be stopped from practicing being Muslim. The Constitution did not stop me from practicing as a Muslim.
And who elevated that new logic? Was it the new dictator that?
No, that new logic. Give me, since you want the things, and I want my audience to understand this. The mullahs took the cases to the court. There was a spirited fight in the court battle, you know. I cannot take you through the entire court battle. But the courts held Ahmadis are not Muslims under the Constitution, yes. They are not Muslims of a special kind. They are not Muslims who believe in Quran. They are not Muslims who want to practice Islam. And they have been doing it for 100 years. They shall not be stopped. So all those practices were allowed and sanctified and protected by a court's judgment. So the court's judgment made it clear that notwithstanding the Second Amendment, the Ahmadis can practice as being Muslims. So that was an end for the mullah.
Right.
They did not take the case to the Supreme Court.
Turning point. Okay.
Then when they did not succeed there, they waited for some time. And when Ziaul Haq came, then he found allies, or
he's the dictator
and the clerics found an ally in the dictator. And what could not be done by the law, what could not be done by the judgment of the court, so in order to do away with the effects of that judgment, martial law dictator brought this, what he said, Ordinance 20. And Ordinance 20 starts with a phrase, notwithstanding any judgment of court or any other law for the time being in force, this ordinance shall have effect. So the ordinance was meant to do away with the judgment which allowed of all those practices. So that is how it came about.
I see.
So Ordinance 20 came in 1984 when Ziaul Haq came in. And Ziaul Haq did that. Initially he was not so keen to do it. He had his own religious agenda, no doubt. But he was at that moment gasping for legitimacy. He wanted allies, and he found allies in the clerics, and he wanted to appease the clerics, and he wanted to push forward his Islamic agenda, whatever he meant by that. None of the laws passed by Ziaul Haq are strictly Islamic. Even these Muslims believe that they are not Islamic. They are against Islam. Each one of law promulgated by Ziaul Haq under the name of Islam is clearly in violation of Islamic jurisprudence.
So let's switch to, so what happened after 1984? When did the Ahmadiyya Muslim community finally legally challenge anything in Pakistan?
So it's very important to note that the constitutional amendment defined who is or is not a Muslim. It was Ordinance 20 that criminalized Ahmadi activities through punishment. That included fine and imprisonment. That eventually, through the Criminal Law Act of 1986 and through a series of maneuvers, included capital punishment. So the threat, that sword that hung over the Ahmadis, that your very existence, your activities, your manifestation of your activities, reciting the azan, saying assalamu alaikum, the very basic acts of witnessing your faith can become criminal. So that created a lot of litigation all through the provincial levels, and those cases then started emanating. And several of those cases then emerged, and there were several challenges to Ordinance 20. But you have to realize that even though Pakistan is a constitutional democracy, it is also guided explicitly by Sharia principles, and there is Shariat court system. So Ordinance 20 was challenged first from its Islamic sense. And Mujeeb-ur-Rahman very eloquently explained that each aspect of Ordinance 20 was un-Islamic, but he can tell you exactly about that case because he was heavily involved in it.
But I want you guys to explain from an outside what you read about it. Just tell me what it was. What was this case?
The Zahiruddin
Yes.
case? So the Zahiruddin case is, Amjad has actually written on it. I mean, that case basically is a bizarre case because the analogy they use is that, well, why is it that, you know, Ahmadis under Ordinance 20 can no longer say that we are a Muslim, or we cannot refer to our place of worship as a mosque? And the judges relied on trademark law to basically say that, well, just how
What is trademark law?
Trademark law is that, you know, if you're manufacturing Coca-Cola, you can't you and I can't bottle something or can something up and say that this is Coke. So the idea is that just as trademark law prevents me or you from making something, like an Apple iPhone, right?
Right.
That's not an iPhone. When an Ahmadi is using any Islamic terminology, we are violating trademark law. And it's an absurd argument. And it seems very ripe.
But that was the argument.
That was the argument in the constitutional Pakistan Supreme Court. But before that step, because you asked about the challenge, there was a key case in the federal Shariat court that challenged whether or not Ordinance 20 was repugnant to Quranic and Islamic teachings.
Right.
And that is a very important case because that set the framework and it was upheld that these laws are Islamic. Then those cases, those laws were challenged through petitioners who were reciting the kalima. And several of those petitioners, the case became Zahiruddin versus State of Pakistan, took that case and went all the way up to the highest court of the land, the equivalent of the US Supreme Court. And that's when the court held that Pakistan has a right to coin its epithets. So Assalamu alaikum is a phrase that is specific to Islam, and Pakistan has an ownership right in that. And Ahmadis are violating perpetually that right by using the phrase Assalamu alaikum. That was one argument. The second argument, which is very important to understand, is that by virtue of Ahmadi manifestation of their activities, they were disrupting they were creating a public safety disorder in the land. And in the name of protecting public safety, we can restrict freedom of religion.
So tell me about this case. I mean, what was your role in this case, Mr. Rahman?
You mean the Shariat court case?
The Zahiruddin case.
I was one of the counsel in Zahiruddin case. In fact, Zahiruddin was one of the accused who was convicted by a court in Quetta. And I had filed an appeal in Quetta High Court, and that appeal was dismissed. And then we brought the case to Supreme Court. And in Zahiruddin case, there were 8 other appeals which were clubbed together and heard together, all touching on the same. The main argument was that the Ordinance 20 is violative of Article 20 of the Constitution, is violative of the fundamental rights, and therefore the law is bad, it needs to be struck down. Then another argument was that the Ordinance 20 is too vague and overbroad. And in our legal terminology, when the law is vague and overbroad, you do not know what constitutes an offence, what does not. It's a bad law, it needs to be struck down. Ordinance 20 is so vague, which says I should not pose as a Muslim. It doesn't define how do I pose as a Muslim. Do I pose as a Muslim because I'm wearing a beard? Do I pose as a Muslim because I'm wearing a shalwar and kurta? Or do I pose as a Muslim because I say God is one? I mean, it's so. The result was that every day-to-day social activity, Assalamu alaikum, is spontaneous, wishing each other, good morning, good morning, good morning. You just do it spontaneously, reflex action. That became an offence, and people were convicted. So those cases were taken to the Supreme Court.
So what was your argument when you were leading this case? What was your argument against the trademark?
My 2 basic arguments were that the ordinance is violative of fundamental rights, is violative of the Constitution, and should be struck down. And the reason why it should be struck down, it was too overbroad and too vague. The application was bad. Then again, the offences which were created, 298B and 298C, they were discussed, and the particular individual cases were also discussed. So it was then other controversies came in, whether the Constitution prevails or whether the Islamic provisions prevail. So that also was one of the reasons why our appeal was dismissed. So Zahiruddin case was a very,
how long did it take? Take us there. How long was the case? How many days did it take?
I think the case was argued for about 3 days, and Mr. Fakhruddin Ibrahim, who was one of the retired judges of the Supreme Court and one of the leading lawyers of Pakistan, he was our leader of the team. He argued the constitutional aspect, I argued the criminal aspect of the case, and then the clerics jumped in and they made all kinds of noises. And there is an indication within the judgment itself. And one thing very important, and this is what I want my young lawyers to keep in mind. Zahiruddin and Shariat court case, both of them are split judgments. They are not unanimous judgments. So in United States, they say, one of the judges of the US Supreme Court said, a dissent in the court of last resort is an appeal to the intelligence of a future day to the brooding spirit of law. I am looking forward to that future day when this minority judgment will become a majority view.
Tell me about the split. What was the final?
Now that again is a very peculiar feature of the judge. Apparently it is a split as 1 to 4. There were 5 judges. The judge who gave the dissenting view was the senior judge sitting on the bench, heading the bench, and he granted most of our reliefs. The other judges, the judgment was written by Qadiruddin. They were apparently 4, but when you read the judgments, there were other notes by Justice Salim Akhtar and others. It is not clear. There are many points involved. On certain points, the judgment is 1 to 4, and certain points, the judgment is 2 to 3. On certain points, the judgment is 2 to 2, and one opinion cannot be considered, because one opinion was an opinion which one of the judges had given an opinion in an earlier case, so he neither overruled that opinion nor gave a view why he was changing that view. So that view has to be. So the split is not very clear. That is one of the reasons why I say Zahiruddin is a fit case for revisit, but revisit has to be at a proper time. The things in Pakistan are not as yet not as free as they should be.
So let's go a little further now. So Zahir, what was the final outcome of this case, Mr. Malik?
It's basically, we lost. And we were.
And what does that mean?
What it means is very significant. What it means is that the highest court of Pakistan has upheld as a matter of constitutional principle that Ordinance 20, a criminal law act, is constitutional, can be enforced on Ahmadis, indeed on anyone, but particularly Ordinance 20 or anti-Ahmadi laws, and that essentially it is okay to bring cases, no matter how frivolous, against Ahmadis for basic acts of worship, basic acts of faith. And so right after Zahiruddin, it's very significant, there was an uptick in violence against Ahmadis. In fact, the months right after Zahiruddin, if you analyze the data of acts of violence and charges of cases brought in the months of 1994, 1995, they were larger than they were in the previous few years combined. That is because the extremists who commit these charges, who bring these frivolous charges, they felt emboldened.
So I understand and your pain, and as a community you went through these challenges, but in absolute numbers, compared to other countries where there have been these persecuted communities, the numbers are pretty small. Are you guys making a bigger deal out of this than it is?
Well, I think it's not that the numbers of prosecutions relative to people who've been convicted of blasphemy are roughly 30 to 40% of all cases brought under anti-blasphemy laws, 2 of which are Ordinance 20 include Ahmadis. But the pure number of prosecutions are maybe 1,200. But what is so significant, unprecedented, in all of constitutional jurisprudence across all 56 Islamic countries, is for the highest court of a constitutional democracy to uphold patently discriminatory legislation, and to do it in such a compelling manner, brazen manner. It doesn't exist anywhere. You will not find a case like Zahiruddin anywhere in any other Islamic country.
So, Mr. Malik, what would happen in the U.S. if this case came about in the U.S.? You just got a master's in this space. You spent a lot of time thinking about it.
I mean, I think that it's not even in the U.S. In any other country, I can't imagine a law like this, a constitutional amendment like this, being passed in the U.S. I mean, it's like when Mitt Romney is running for president, and if you go up to him and tell him that, well, look, I mean, you can call yourself a Mormon, but don't call yourself a Christian, and don't refer to that the temple of the church, because I'm the majority, and Mr. Mujeeb-ur-Rahman mentioned James Madison. There's this concept of tyranny of the majority. That's what our founders categorically rejected during the early days of our union. And I think that in Pakistan, what is happening with the Ahmadis is in fact tyranny of the majority.
But it's the law now. Why not? I mean, the old argument, love it or leave it.
Well, then you have Dred Scott, right? I mean, then, we can still continue to believe that, if you're a slave, you're not a human being. I mean, laws are there to be changed, and I think that as society evolves, we hope that our laws become more in sync with what our true inner values are. And I think that the law in Pakistan, I think that anybody, whether it's in the US or I believe anywhere else in the world, I mean, I think that your conscience tells you that this law is clearly discriminatory and it's un-Islamic. I mean, that's the biggest irony to me, that it's in an Islamic country, but it has nothing to do with Islam. Islam is not about making these kind of judgments.
You said, just a minute, you said what would happen if the case were to be in the United States. It would be thrown out on the very first hearing. Why I say that? Because United States has passed through that experience. Way back in 1930, Jehovah's Witnesses were facing the same kind of persecution, and the American Supreme Court denied them the fundamental right. But the civil liberty unions in the United States were so strong that within a period of 3 years, the judgment was overturned by the United States Supreme Court. So why do I not take it or leave it? Because the United States experience is that the judgment was overturned in 3 years. In my case, it may take 3 decades, but it may take a little more. But one day, I'm sure this judgment will be overturned.
So what happens now? We've got just a few minutes left, and from each one of you, it is the law. A lot of people have unfortunately been killed as a direct outcome of this law. There's a lot of sad things that have happened, and it's been a while now. So what happens now? What does your community do now in Pakistan? We'll start with Mr. Khan.
It's a very good question. First and foremost, the implications of this decision are not just simply legal. They have tremendous implications, including political. For example, Ahmadis can only vote if they call themselves non-Muslim. Imagine several million block of voters who are among the most literate in Pakistan are, through a single stroke of a pen, denied the right to vote. That is because of the 74 Amendment. That is because of Ordinance 20. That is because of the Shariat Court judgment. That is because of Zahiruddin. So the implications here are dramatic. The democratic movement of a very intellectual community is suppressed. So the future for our Ahmadis, how we deal with this, is we dismantle, slowly but surely, the legal apparatus that has caused this pain. We do it by challenging the passport form that requires us to declare our founder to be an imposter. We do it by pushing for the Executive Order 15 that was passed in 2002 to be repealed so we can have the right to vote. We do it by becoming, as citizens of Pakistan, by participating in the very democracy that we helped contribute to build.
Mr. Malik.
I think that, first of all, I would like to say that these laws have not harmed Ahmadis as much as they have harmed Pakistan. I think that's something that we have to understand. That
What does the Ahmadiyya Muslim community do now? What can they do?
I think that what we do is we just wait and we wait for Pakistan to get its act together. I think that we mount a legal challenge, as Mr. Mujeeb-ur-Rahman said, when the time is right. But currently, Pakistani society is in a tailspin, and I think that this is not the right time because that country is now, unfortunately, in a struggle for its existence, and I think that they're not capable to make any hard decisions.
The Ahmadiyya community, by its faith, by its philosophy, by its ideology, does not believe in violence. So our reaction is not going to be violent. Okay. It has not been violent so far. It will not be violent in future. But our battle has been legal battle. We'll fight it out in the court.
So how do you go back to that legal battle?
The legal battle is not so far favoring us. We'll continue waging it as long as we can. But at the same time, we are trying to the best of our ability to enlighten the public opinion. And as Qudus Malik just now said, because it is the Pakistan in the ultimate analysis that stands to suffer in the long run. It is the Pakistan society that has been radicalized on account of this attitude of the state and religion being intermingled. So we keep on trying. We are loyal citizens of Pakistan. My patriotism is no less than anybody else. My patriotism is under big pressure on account of the persecution, but my patriotism stands out. And my patriotism does not allow me to do anything against the interests of the state. But I am at my deepest concern about my country. So I will try to mold the public opinion of my country as long as I can.
That's a great way to close this segment. And This has been another show of Open Forum where we've discussed the 40 years of being declared kafirs of the Ahmadiyya Muslim community in Pakistan and how it happened, when it happened, and what the Ahmadiyya Muslim community is to do about it. Learned a lot, including it will not respond by violence in the past or the future. Thank you for joining Open Forum.